Good afternoon.
Hi, how you doing?
I'm Carol Ann Conboy, recently retired Justice of the New Hampshire Supreme Court. I have the pleasure of interviewing for the Oral History Project my former partner, Attorney Bruce Felmly of the McLean Middleton Law Firm. It's good to see you, Bruce.
Good to see you. I hope you're enjoying your newfound freedom of time.
I'm working on it.
It's fun to sit down and talk with you.
Why don't we just begin at the beginning and talk a little bit about your education and what brought you to law school?
Sure. I had grown up in New Jersey. I didn't really have a remarkable high school education. I did fine, but I wasn't a very disciplined student. I went off to the University of Rhode Island as an undergraduate, mostly because on the weekend we visited, there was a great beach weekend. The waves were coming in at Narragansett. I told my folks that I thought I could be comfortable there. And it was a great place for me. So I went to the University of Rhode Island. I didn't have much of a direction or mission. I enrolled in business administration because my father was a businessman. And then decided I liked the courses that were in liberal arts more, and what do you do if you get a liberal arts education? And I noticed upperclassmen friends of mine going off to law school, and without a whole lot of vision or planning, by that time I was a good student, and I was fortunate to get into a lot of good law schools and went to Cornell Law School in Ithaca, New York, which was almost a perfect place for me. It's a smaller size school. It's got a great program. It's a wonderful place to live. We were just married, Susan and I had met my wife at Rhode Island. So all those things came together, but I can't say there was much of a strategy or tactical plan that put it together.
I think it would be accurate for me to say that you are a very well-known litigator in New Hampshire and in some states across the country. Did you have a burning desire to be a litigator when you were in law school?
No, I did moot court and enjoyed the evidence courses and some of the trial-related courses, but I didn't have a vision of being a trial lawyer alone. And in fact, even as I applied for positions when I was leaving Cornell, they were not all in litigation area. And the McLean firm at that time, which would have been McLean, Carlton, Graff, Green, and Brown, it's changed the name so many times. We've now adopted an institutional name. You know, when you came in there, you did everything, not just by happenstance, but by design. You know, you really were expected to know how to handle an income tax issue, or resolve an estate, or administer an estate, or sell or foreclose on real estate. And so the first 3 or 4 years in particular, I did almost anything you could possibly do. I'm not sure that's a great plan for training associates. It's certainly not an economical one in today's marketplace. On the other hand, it gave me a pretty wide omnibus view of law and people and New Hampshire and lots of different things.
When did you start at the firm?
I started on the second day of August of '72 and never left, as some people are inclined to tell me.
And so you have been there for
45 years.
45 years.
On August 2nd, a number of people came down the hall with some chocolates and flowers and, and said, "It's your anniversary," and I had forgotten it, so it wasn't a complete surprise. I knew it was a long time, so at any rate, it's 45 years.
Well, you know, that's interesting because I think young lawyers today fully expect that they're going to have 3, 4, or even more positions for an entire career.
Yeah. You know, a couple of thoughts on that. I think that in a lot of ways, while that is now experienced by our firm as we hire new people, there's a whole lot of my colleagues there who sort of never left, and that's been a strength of the place. And then folks that have left have stayed in close contact. You know, somebody like you that's gone on the bench, you still, are willing to talk to me on TV and stuff. I think that there are pluses and minuses of that. I mean, I would say there were certainly opportunities to leave and do other things. None of them were nearly as attractive as the position I had, and I really never really aspired to be a judge or, I wasn't active in politics. By the time I was trying a lot of cases, I was, very much wedded to enjoying that, and there wasn't really a more interesting or better job out there for me. So if I was going to practice law, I was going to do it at McLean Middleton, and I was going to practice law because I'm not a very good carpenter or painter. So
when you arrived at McLean, who were the senior partners there?
Yeah. Well, it was sort of a remarkable time. It would be sort of like arriving at the U.S. Senate with Daniel Webster and John Calhoun and people like that present. Kenneth Graff was still extremely active. He was one of the founders of the firm. He was also the president of Rockingham Park Racetrack, which he sort of ran in his part-time. You had Arthur Green, who some of you know Arthur Green, the younger lawyer who's now the professional consultant. He's a little older than me. His father was the one I'm talking about, and he had tried cases for years. You still had Stanley Brown there for several more years before Stanley decided to leave and open his own firm. Harriet Mansfield, one of the first female lawyers in the state, somebody who never went to law school but read law, sitting at I guess the desk of Judge McLean and learning from him. She was still there. All these folks were remarkable. And then you had a whole bunch of other folks that were really just hitting their prime. Jack Middleton and Bob Rollerson, Charlie de Grandpré, John Graff, who we lost in about 1993. John tragically died early, but John was extremely vital and active at that time. Jim Muirhead was a very established litigator. So when I came in there, it was just a remarkable time to experience the sort of last few years of some of the more senior people who were bigger than life in many respects, as well as seeing the folks who I could really learn from that were really involved in the most significant cases, I suppose, in the state and sometimes the region. It was a spectacular time to start practice.
Who was your role model?
They would not take credit for me, so they would probably say, "Don't say it that way." I worked a tremendous amount with Jack Middleton and with Jim Muirhead, and particularly once we started trying cases, I carried Jack's bag for many years on lots of different cases. We were trying a lot of cases then. I mean, you bounce from one case to another. They were all different types of legal problems. They were all over the state. And you were learning by the bucketful every day by doing things. But I would say Jack and Jim Muirhead were key mentors. Charlie de Grandpré was evolving into a more of a trust and estates and commercial lawyer at the time. So Charlie always had a fondness for litigators, and he was a bit of a mentor, but it was mostly in the context of, why did you say that at that directors meeting? Wouldn't it, he was more an advisor and sort of a cultural attaché rather than this is the way you should try the case.
Right. In the early years, was the practice terribly different than it is today?
Oh, it was different in so many ways. I think the basic skill set that makes you successful is probably about the same. You need to be great at analyzing and solving problems. You need to be a good communicator with clients, which is another word for people under terrible stress and needing help. But then if you look at the pace of practice, just how fast things move. When I cleared my email before we started this interview, and we'll go an hour or so, and when I finish there will be more than 20 emails on that when I light it up again, half of which will be unimportant, several of which are going to be very important, and I know what they're going to be. So I think that the expectations of clients on turnaround time, staying in touch, there are very few occasions in the kind of cases I'm fortunate to work on where you can really turn off the machines and say, I'm out of touch for the next 3 or 4 days. And that was not the situation back then. People corresponded, they talked on the phone, a letter took 3 days to get through the mail.
Yes,
You
yeah.
went on vacation to Montana for 2 weeks, and you called in maybe once while you were gone. And that's not to say there weren't ever crises. There were crises, but you didn't necessarily have this expectation of instantaneous response.
Yeah.
That's really the major difference, I think.
Yeah.
And if you're not able to manage that and figure out how to handle that, you probably need to be doing different work, I'm afraid.
Yeah, yeah. As you are maybe headed toward retirement, is there any way you can crank it down a few notches, or is this just the kind of work that is full tilt or nothing?
We're going to have to find that out. I don't have the answer to that. I've watched and consulted with, and I have a lot of colleagues, many of whom are some of the finest trial lawyers in the country from the American College of Trial Lawyers, and I've watched different models. I would like it to be a model where I could transition it and slowly modulate it down. But then the phone rings, and you have to decide when a large company calls you and says, you know, we've been sued in a major case, are you going to say, I'm delighted you called, I'm very flattered, I'd love to work with you on this. And then they say, well, how long do you think this case will last? It's not going to be 2 weeks. It's going to be 18 months or 2 years. And then you have to either commit yourself to doing it or come up with plan B. So I think that, you know, there are some successful models of people that have turned it, you know, down a bit. I'm not sure that those people, when looking back at me, would say that my personality is perfect for that. So we'll have to see how that works out. I've always, you know, been very fortunate in this profession. I've had the opportunity to work on large cases and sometimes small cases that had large implications for people, and still be able to, you know, have a very good family life and have lots of passions outside the law. You know, work hard, play hard is a great model if you can pull it off, but you're not going to sleep an 8-hour night if you're doing that, I can tell you.
I think I'm accurate when I say that you have a somewhat unusual litigation practice in that you are not particularly focused in one area. You are not the med-mal defense attorney. You're not the construction case attorney. You really have had quite the breadth. Tell us how that happened and how you do that, because I think a lot of attorneys would say, I don't know that I could do that.
Well, it doesn't happen really by design. It happened, you know, a bit by evolution, and it's a long story, and our listeners probably won't hang on the edge of their chair to hear it. I think that there are a couple of big divisions that come into play there. Most litigators tend to either end up in a sort of partisan way on the defense side or the plaintiff side. In commercial litigation, those sides are blurred because there's commonly counterclaims and who's the real plaintiff and stuff. I really did a pretty heavy diet of plaintiffs' personal injury cases in what was a much smaller firm then, but it was still New Hampshire's larger firm. I've never worked in a firm that wasn't New Hampshire's largest law firm, although it started at 18 and now it's 100 and something. And I think that partly because of you know, things beyond our control, Jim Muirhead decided he wanted to be, you know, a jurist. Other people went into different areas, and the demands for developing the business litigation practice became a pretty critical priority. And the idea of me trying a steady diet of plaintiffs' products liability cases or medical negligence cases or, you know, horrible auto accident cases, even though we were making, you know, very good money at that, deploying a team of people that could handle the state's largest business cases was critical. And the deal was pretty simple. You got to do that, you know. I remember the day I learned that Jim Muirhead had taken the magistrate judge position in the federal court. I didn't even know he had applied. And I was sitting next to the then Chief Justice, David Brock, at a conference, and he said to me, that's pretty interesting news about Jim Muirhead this morning. I said, is he okay? I said, he said, what do you mean, is he okay? He just took the federal magistrate job. I said, really? And instantly I said, that's going to affect me, because I was one of the more senior trial lawyers coming up through the ranks at that time, and something of a prodigy of Jim's, which is an interesting experience in lots of respects. And indeed, I don't think there was a cell phone call, but I called the office and I said, is that true? And yes, and the management committee would like to meet with you at 3 o'clock when you get back, because we have some corporate clients we've got to go visit. And at that time, I started doing a tremendous amount of business litigation work, and that has become, significantly more than 50% of my practice, and then took me beyond New Hampshire.
Right.
And that's been tremendously exciting and rewarding and demanding, staggeringly demanding. But that's the way things sometimes happen. It isn't always that you fill out an application and apply for the job.
As you look back, are there some particular cases that really stand out in your memory as being especially demanding, either legally or given the players?
Oh, just scores. Yeah, sure, sure. Get another tape. Just a couple that just for different reasons. So the Rockingham racetrack in Salem, New Hampshire burned one day with a high suspicion of arson. Indeed, there had been multiple major racetrack fires in the ensuing 4 or 5 years, and there were all kinds of conspiracy theories going about. And Kenneth Graff, the then senior partner, was very involved in the insurance claim, and Muirhead and I were handling that claim, which was many, many millions of dollars. It was a complicated claim because, the issue of what is the value of a racetrack and what is this very unique sort of one-off building that was, you weren't going to go out and do a lot of comparables on Home Depots and try to figure out how to value this thing. And a very challenging client who happened to be our senior partner and was not going to tolerate anything less than a Grand Slam home run. So that was fascinating, and just dealing with Mr. Graff. The most stunning memory I have of it is after we had decided and negotiated on a settlement with the insurance company that took many, many months and was extremely contentious. The day came for the money to be transferred, and this was probably in the early 80s, maybe the late 70s. And the issue was, my memory was that the insurance company would only transfer the funds by wire transfer, which Kenneth Graff, an extremely sophisticated man and businessman, did not trust wire transfers. And literally we went over to what was then the Amoskeag Bank, and the monies came into the account that was there, and he insisted that he and I watch the wire transfer and actually watch the ticker tape bring the money up, and then had the president of the bank say, yes, it's really in the account. And then he said, I will sign the release. And that was the way in which the settlement occurred. And that would be a little different today. So that was a remarkable case. I tried a case for 5 weeks on behalf of a family that lost a kid in a car crash, and we sued together with Ted McCain up in Laconia, the Ford Motor Company, because of essentially the story of how airbags had not been put in cars from the 1970s when they became technologically available, and this accident happened 20-some years later or so. So we were trying a case that the car was inherently dangerous, and that had all kinds of challenges and all kinds of interesting and exciting things. But the most sort of remarkable single piece of it was the fact that the decision by Ford not to put the airbags that were then in prototype into the cars back in the 70s was ultimately a deal struck significantly in the Oval Office with Richard Nixon and with Ehrlichman and with Haldeman and Lee Iacocca.
How did you get to that information?
All of America got that information because when the Watergate tapes were released, one of the things that people sort of forget about that is all the other unrelated byproduct stuff that came out that nobody was paying attention with. Everybody was worried about, who was paying G. Gordon Liddy. But a lot of plaintiffs' lawyers doing airbag cases were noticing the fact that there was discussions as to essentially what the federal government was going to permit Ford to do, and there was not a lot of enthusiasm in the White House towards pushing this. So this remarkable bit of evidence is out there, and I had subpoenaed Ehrlichman, John Ehrlichman, and Ehrlichman was a little bit on the circuit doing testimony, and I had him all lined up for a videotape deposition, and Ford moved to quash it on grounds that I was grandstanding, which was true. And Harry Perkins, the judge at the time, was saying...
State judge
was saying, you know, Bruce, you're grandstanding, because I had also subpoenaed Lee Iacocca, and he was still around. And the bottom line was that the judge says, look, you know, I'm not going to let you go there. It's just too far afield. I think it's a little bit of a circus, this and that. But he said, you know, maybe you know, it's a motion in limine, maybe the door will get open. So we're trying the case, and we're in probably the third week of trial. The defense expert is on the stand, and he's talking about it. And I'm essentially saying, you know, impeaching him on his background and stuff. And he says, well, that's not true. He says, I've been involved in this for many, many years. In fact, I was in the Oval Office talking with the President of the United States with the President of Ford. I was there at that meeting. You can read about it in the Watergate tapes. And I looked at the judge, and the judge has a smile that goes from one end and basically said this and did a motion of the doors open. Of course, counsel rushes to the sidebar, and we had the Watergate transcripts all with National Archives seals and everything on it, and put it all in. So that was a fun case to try. You know, the other cases that are memorable are all sad stories, or many of them are. Cases involving parents that lost children, horrible medical mistakes, sometimes admitted, sometimes not, sometimes won with large verdicts, sometimes not. You know, long nights of preparation. I can think of, you know, used to do all-nighters in college studying for an exam. Doing an all-nighter when at 9:15 in the morning you're going to start the cross-examination, what seems like the cross-examination of a lifetime. That's a long night. It's a long, lonely night getting it organized. So there's many cases that come to mind.
There was one that maybe our listeners would enjoy hearing about, the Timber Lane school strike.
Yeah, and when I was first starting to practice, the teachers in Timber Lane were in a labor controversy with the supervisory union or the school district, and ultimately went out on strike. And the law of teachers striking was not favorable for teachers striking, and so Jack Middleton was representing the New Hampshire Education Association and ultimately the Timber Lane teachers, and I was the associate on that file. We had multiple cases involving that because they were fired, and there was a decertification action by the state against them, and that essentially meant that they were going to lose their teaching licenses. So the stakes were extremely high for these teachers. And we were in front of Judge Bounds in the federal court seeking injunctions and various things. The state had a provision at the time, I don't think it was a statute, it must have been a rule or something, but basically it said that any teacher who violated the spirit and intent of an in-force teaching contract could be decertified. And we argued vagueness and ambiguity and basically said, you know, that is a completely invalid statute. It doesn't provide sufficient direction. The only example we could ever find that was a similar sort of edict was in Imperial China in about the 12th century AD. They had a similar sort of, any citizen or member of the empire who violates the intent of the emperor's order, because you have to sort of think about, well, how far can I go? The intent here wasn't exactly clear. So that was a fascinating case, and we were bailing out teachers who were being arrested for picketing and trying to keep their teaching certificates, and those kinds of things are a little bit like the defense of the Bataan Peninsula. You lose several thousand yards of ground a day and hope that somebody gets out alive. You know?
Yeah. What about cases that you've had where the client has been particularly difficult? You don't have to reveal anything, but I'm just always interested in how people like you, very successful litigators, handle clients who either expect you to be the hired gun that they see on TV, or have issues that may just extend way beyond the issues in the case.
Well, they come in different flavors a bit, the difficult clients. The ones that are the easiest are the ones that are just extremely demanding, instantaneous response. I have a client that in the past used to call me, never called, I don't think, before 10 o'clock at night because he was a night owl. And those are just, you got to figure out some ground rules and manage them. And then you have the clients that are mentally disturbed, and in many respects, they're the most difficult. And those are folks that you have difficulty explaining what we're doing. You have no ability to rely on what the client's going to necessarily tell you. They do things that can be bad for their case or bad for you. I had a client who was extremely intelligent young woman with severe mental problems, a history of suicide ideology. We had tried a case for her. It was an unbelievably stressful event. We'd gotten a very large verdict. It was on appeal. And it took a while for that case to work through the appellate process. And she lost it at various times, was hospitalized in a mental institution at various times. And maybe the low point was when the clerk of the Supreme Court called me to tell me that the Chief Justice would appreciate it if my client would not call him at home, asking him to move this thing along. And they understood it. I mean, they got it. Sure. But those kinds of things are stressful. I've had clients who were so disturbed that I had to warn my family about risk of personal safety, because you'd think that the client will only become a risk to the opposing party. But that's not true. If the frustrations levels is high enough, you can get into that phenomenon where everybody's going to die. I've only had that maybe once or twice, but they were memorable. I actually had to give very specific instructions to my spouse about a particular client one time who kept threatening to come to my house and teach me a lesson. Just withdrawing is not going to solve that problem.
Right.
And you have clients that are so despondent and so depressed that they can't hardly manage, and you're the only thing that they think is keeping them alive. And it's I've had clients commit suicide on my watch, and I've had a number that were at risk for it, and that's a burden that is very, very troublesome and difficult. So there's different layers to these things. The only time that somebody actually took their life would have been the person that I least expected it, frankly. It was somebody that had problems and challenges in their life that became clear after their death, but never would have anticipated that they were going to kill themselves. Yeah.
Thinking back, do you have some favorite judges that you liked to appear in front of, and who were they? And
well,
why?
sure. I mentioned before Judge Harry Perkins. He was a judge I really liked appearing in front of. He was a tough taskmaster. He was a no-nonsense guy, but he had a great sense of humor. He liked lawyers. He understood the trial process and the stresses of it. He was willing to let you try your case. He would make rulings. I never kept track of how many I won and how many I lost on his rulings, but I wasn't getting any favoritism. But he was a very, very passionate fly fisherman, as am I. So even if he was going to rule against me, he would tell me a great fishing spot I could go to soothe my troubles. So he was wonderful. I think Marty Laughlin, who was on both our state bench and on the federal bench, was again a wonderful, real judge's judge. May not have been the most distinguished, legal mind of the century, although sometimes he thought he was, and he read a book on something. But he had great common sense. He had a great compassion, a great feel for people. He knew everybody in New Hampshire. Got it, appreciated great advocacy. I think Hugh Bounds on the federal bench, it was a marvelous legal mind and a very practical person. You know, I was fortunate to have argued a couple of cases before Judge Kennison while he was on the Supreme Court and before his death, and always enjoyed that. I had the opportunity to appear in front of David Souter. These are great legal minds, wonderful judges. But we got great judges now. I mean, I think that you know, some of the people that are on the bench now will be seen in later years as easily the equal of some of those supposed giants. You know, we have a much more diverse bench now. We have, in the day, there were very few female judges. You know, you made a big difference in that, but not alone. Judge Delanus and others did, and that was a huge plus for the practice of law in New Hampshire, I think.
Since you have been involved in cases out of state, I think it's always interesting to talk about the differences in practicing law in New Hampshire and other states. We like to think that we're very collegial, that we still are small, that we know each other. What have been your observations about the difference in practicing law in New Hampshire as opposed to other states?
Yeah, I think that, like a lot of things, the more things change, the more they stay the same. You know, I've practiced a great deal in the metropolitan New York area and out on Long Island. And I will say that the rough and tumble practice of New York lawyers in the trial court is different than New Hampshire. And I'm not sure that it's the people are different. I think the numbers and just the anonymity causes people to not necessarily remember that, you know, they're going to bump into this person again and their reputation is going to follow them. So, you know, large volumes of cases and lawyers sometimes doesn't enhance collegiality. But the quality of the judges, the quality of advocacy, the ability to present the case, I've never been disappointed down there. And then I've tried cases in South Carolina and Missouri and Connecticut and Massachusetts and other places. The major difference and the thing that always struck me the most and concerned me the most is I didn't sort of know the local culture, customs. Do I stand up now? You know, do I have to do the hokey pokey before I make this motion? You really need to have somebody that is really tuned in. If you're going to come from away, with a capital A, as we say in New Hampshire, if you're going to come from away and try a case in the county court in Missouri, as I did for 4 or 5 weeks some years ago, you better have a local counsel that is really, really savvy and knows the layout of the court. It may not have to be on a first name basis with every bailiff, but it isn't harmful if they are. And it just makes you got to get comfortable in order to do this job at a high level. You can't be sitting there worrying about some intricate problem of courtroom decorum or practice. The first time I ever really did an intense voir dire of a jury was in Missouri, and it went 2.5 days. And talking to a jury, it wasn't just me, the other side too, but talking to jurors for 2.5 days, when you've never really done that before, you're sort of preoccupied with, I don't want to say the wrong thing and destroy the process. My Missouri counsel says you can say anything you want in voir dire. You can argue anything. I don't care if there's a motion to eliminate. You can argue anything you want. Just ask him about it. And the judge is sitting there. He's not going to come down on you in voir. It's voir dire. You can say anything you want. You know, and he was right. You could say anything you want. Evidence that would it bother you to find out that he had confessed? You know, you could say anything you want. It wouldn't matter. That probably would strain it. It wasn't a criminal case. But the gist of it was you could say anything you want. And without that kind of, and I sort of did for 2.5 days. But I think you have to figure out a way to become assimilated into that culture. And so you get up early, you get to the court early, you go out of your way to, you know, meet the stenographer, you introduce yourself, you talk about New Hampshire. It's always good to have an explanation of why you're there. I was in the appellate division in the 2nd Department last week in New York arguing a case, and the bailiff was sort of interested there with all the guns and everything on in the security system as to why a guy from New Hampshire was there. And I said, well, you didn't hear? I said, New York is running out of lawyers. they're bussing them in from New Hampshire. They looked at me for a second and realized I was giving them the business. And we were okay from that point on. I said, here's the good news. They're all coming up to New Hampshire to try their cases. So turnabout's fair play.
Yeah, yeah. Just shifting a little bit, you have been very involved in a number of extracurricular activities. You were involved in drafting of the New Hampshire Rules of Civil Procedure. You were president of the New Hampshire Bar. You were elected to the American College of Trial Lawyers. You've been on the Long Range Planning Task Force. A lot of major commitments. How do you do that? How do you do the kinds of things that you have done to contribute to the legal community and still practice law?
Well, there's a couple of answers to that. One is I wouldn't underestimate the importance of growing up as a lawyer in an environment that respected, encouraged, and treasured those activities. I mean, when you look at who the people were who I mentioned as mentors, Jack Middleton has done all of what I've done in those list of things by, probably an order of magnitude 10 times more. And so to some degree, we are trained and brought up that way. Hopefully we're teaching and mentoring, our junior parties. It's not by accident that Scott Harris and Jennifer Parent and, other people have been president of the bar. So part of it is being in a place where you're not going to have to explain to your partners why you may be unavailable for a meeting or why your billable hours might have been down last month or something. I think the second piece of it is just the nature of litigators and what they do. They are drawn to those types of things. It's not a surprise that many of the people who serve in leadership, like the president of the bar, are going to be trial lawyers. They're comfortable in their own skin. They're comfortable speaking. They are frequently raconteurs. They like lawyers. They like storytelling. They don't mind going out to evening meetings and meeting colleagues and friends. They like trading on their reputation. When you're active and you're out there and you're walking the walk and talking the talk, cases tend to come your way. I don't know that I would have done that if I was a municipal bond lawyer, in some dark paneled room, reviewing stacks of papers for a living. I don't think I would have done that. I think the embedded question is, how do you find the time to do it? And the answer to that is you have to become, to do at least my type of practice and those kind of activities, you have to be very well organized. You need remarkably good assistance. You probably will not do your own scheduling. I don't do very much of my own scheduling. You will talk to my assistant who will tell you when and where I do things, and they're in touch with me multiple times a day. We go through Outlook calendars every day. The Outlook calendar gets ripped off and a new one comes in, and it's online, but it changes daily. And you have to have that. You can't be doing that just on your own and trying to remember where you're going to be. I mean, I called in yesterday as I was out of the office, and I said to Michelle, I need you to put together a to-do list with every activity I'm going to be involved in for the next 2 weeks, because I got a lot on my plate right now. There's a lot going on. I've got some business travel, and I rely on her to make sure I'm in the right place at the right time. And finally, you have to enjoy it, or there's no point in doing it. All those things are a lot of fun. They were enormously rewarding.
But even though you enjoy it, obviously there's a real challenge to achieve that balance point where you're really busy doing what you like to do, both practicing and contributing to the bar, and having a satisfying, rich, comforting personal life. How do you make that happen? I mean, I think a lot of lawyers would say, how can you maintain your sanity running around doing all this stuff?
Well, I hope I've maintained my sanity. I mean, that would be sort of the baseline. There are people, including some of my family, who would question that. I'm not a great believer in work-life, personal life balance. I don't think that's an accurate way to describe it. I love the concept. I wish it were true. I wish it were even achievable.
Yeah.
I think it would be great.
Yeah.
I think we kid ourselves into it because it implies a status of equilibrium that has a constancy to it or will somehow perpetuate. And as long as you keep, balancing it, it will stay on that course. That's not my experience watching other people who do what I do. What you have to be is extremely good in figuring out how to prioritize the things that need to be prioritized in each of the dimensions of your life when they're occurring, rate them, although you do it subliminally, and be there for not only the argument in the Supreme Court on Thursday morning and the deposition on Friday afternoon, but we're going to the school because the kids are doing a school play at 11 o'clock on Friday. We are absolutely going to be in Rangeley, Maine at our cottage on the weekend. No ifs, ands, or buts. Even if I have to take 2 briefcases and get up at 5 in the morning and do something, we're not canceling that just because a preliminary injunction hearing's been scheduled. You communicate effectively and you will fail. You will have your spouse tell you, you forgot to tell me you were going to the Bar Foundation dinner tonight, but I didn't this morning, I remembered, and we are going there. And so I think it's a little bit more like, Pac-Man or one of these games where you keep trying to bang down a different thing that's popping up. And organization is part of it. Liking it is part of it. And not falling asleep in the middle of the afternoon because you're dead tired is part of it. It's challenging. I think where it really becomes difficult, and I've had a lot of this, is I'm doing a little less out-of-state travel right now, not really by design, but just because of the flow of the cases. It may actually expand a lot in the next year. But when you're out of the office for 2.5 days and you're trying to catch a shuttle out of Logan at 7 o'clock in the morning, and the car service is picking you up at 4:30, and you don't know when you're getting home, and there's thunderstorms in Philadelphia, and you're rolling in at crazy, and then you forget, is it Thursday or is it Monday? I mean, it's not too bad if it's Tuesday or Wednesday, but if you don't even get it within 2 or 3 days, that's really tough. And you say, I'm going to read all that on the plane coming home, so I'll be ready the next morning. And you remember getting on the plane and saying hello to the person next to you, and you don't remember anything until they say we've landed, and you miss the drink service and you miss the takeoff and landing because you're asleep. So I think it's very difficult to do it. I think it can be done successfully. Sometimes you just bite off more than you can chew. The only other thing I would say about it is you really have to have a terrific team of people to support you. And if you're a better delegator than I am, you'll do better. I delegate a terrific amount, but it's challenging to delegate.
Because it all comes back to supervising the delegation.
Right,
sure.
And staying on top of it and trying to remember it. I do several to-do lists a day. It all works, but it's not a balance. I mean, really, it is not a status of equilibrium.
Your son is a lawyer.
Yeah, right.
And I wonder how that happened. Did he become a lawyer because you encouraged him? Was he as excited about the law as you obviously are? How did that happen?
Well, again, certainly not by direction or pressure or some sort of a dynasty or legacy role. There's none of that. Peter actually, after graduating with a liberal arts degree from college, said he had no real interest in going to law school, and sort of, Dad, you can't make me. And I said, look, I got to tell you, making you go to law school is number 2,764 on my to-do list. I said, I have no interest in that. support you in whatever you want to do. I would appreciate it if you would think seriously about gainful employment, but you don't have to go to law school. And so he went and got a job with the American Arbitration Association as a sort of a paralegal level case manager, and did great at it. Met a lot of lawyers, met super lawyers down in Boston, was there for several years. And that, all of a sudden woke up one day and said, hey, I can do this. I don't have to be my dad's lawyer. I can be my own lawyer. And it sort of developed that way. He went to law school, did very, very well, and is a partner in a law firm over in Maine and doing really well. And once in a while will call me up and ask me to take him to lunch when he comes to Manchester. And so he's doing fine. I have a lot of friends in the trial bar over there, so I get reports rather frequently on how he's doing, and he's doing great. So it's good. But it wasn't something that was sort of a family tradition or anything like that.
Yeah. You once had an inside glimpse into litigation on the other side. That is, you were a juror. Would you describe your experience?
Yeah, I should probably throw that ball back to you because you were the trial judge on that case. I was called for jury duty in Hillsborough North and was rejected as a juror in multiple impanelings of jurors that week. And okay, Mr. Felmly, we understand you know something about this. And of course, all the lawyers know you're a lawyer and a trial lawyer. Worse, you're a trial lawyer. And so step back and you'd hear him talk, well, I'm a client office, and never got picked. And then there's a case that you were the judge that was the presiding judge on. And it was a criminal case. It was a serious criminal case. It was a home invasion case with burglary of the home, stealing a gun collection, and some other remarkable things that sort of gave the defendant away, as it turned out. But at any rate, the prosecutor and the defense lawyers, for different reasons obviously, concluded I'd be a great juror. I don't know what they were thinking. I've never impaneled a lawyer on a case. I've struck every one of them and have no intention of changing that. So any lawyers out there, if you're selected...
Why?
Well, because
I'm diverting you from the story.
I don't think they will be able to pull off what I pulled off. And the moment that your fellow jurors know you're a lawyer, the game is over. So my fellow jurors did not know. I was in dungarees, a plaid shirt. They did not hear the sidebar discussion. I brought a Tom Clancy novel. I didn't use, if I used my cell phone or my iPhone, they weren't picking up the fact that I was monitoring. I was a business person. I wasn't non-talkative or non-communicative, and I didn't knowingly misrepresent anything about that. And so we go through the trial. The perpetrator is found guilty. It was not a hard call, and
you were elected the foreman.
No.
You
I
weren't.
No, I was
I've misremembered.
No, I'll come back to that.
Okay.
I was asked to be the foreman, and that's the only place where my level of candor became a little bit strained. But I wasn't elected the foreman. So at any rate, we come back, and the clerk comes in and says that the judge would like to come in and thank the jury and meet with them after the verdict. She does that quite commonly, and you came in and were informative and interesting and charming as always, very thankful for their service, something of an American civics lesson. Countries all over the world don't have, so we're all sitting there, and then you decided, unfortunately, to have an afterthought. And as you're sort of getting ready to leave, you said, I'm not sure if you folks here know that one of your members on this panel is a trial lawyer with 35 years of experience. In fact, I used to work with him. I think I tried my first case with him. And, 11 sets of eyes turned to me. And the lady next to me said, "You lied to me." And I said, "I didn't lie to you. What did I lie to you about? You didn't tell us." I said, "That's true." I said, "But would you think that you might have had a different view of me as one of your colleagues here if I'd told you?" And they all agreed it probably would, because they had tons of questions about a lot of aspects of this case. And another guy said, "Well, you lied to me because I asked you where you worked." And I said, "And what did I say?" He says, "You told me you worked in an office in Manchester." I said, that's actually true. I said, it's not my fault if you don't follow up with the right question. So to make a long story short, we had a good, after the initial sort of disappointment, and one guy said to me, I'll tell you what your lie was, Bruce. When we asked you if you'd be the foreman, you said, you really don't like to take leadership positions. I said, you got me on that one. I said, that is a bit of a stretch, but I had to take that position because you end up becoming the authority. And I've never had a lawyer on a jury, but I once had a mistake of having a private investigator on a jury. A former cop, detective who became a private investigator. And the case had some conspiratorial issues, even though it was a civil case. And that was a huge mistake. He was like a drill sergeant with that jury, you know. And the result was it disproportionately affected the outcome, I believe. And I won't make that mistake again.
Right. What did you learn by being a juror? You know, trial lawyers like to talk about what the jurors may be thinking, who may be with them, who may be against them. What was your experience?
Well, in my case, I think the jurors reflected a common wisdom that we have about jurors, which is those 12 sets of eyes don't miss a lot that's going on in the courtroom. So they were very tuned into who the spectators were and what their probable relationship was to the case, because they knew they weren't from CNN News. They knew they were family members or victims or whatever. They're very fascinated in the interaction between the criminal defendant and counsel, because this criminal defendant, who was an idiot and who made not just a bad moral decision to break into this home, but if you're going to break into a home and steal guns, stop there, don't take one other thing that might give you away. And he knew this family, and he was close to the teenage son of the family. And he had given, before he went to prison the first time, the son of the family that was broken into, his love letters with his girlfriend, because he was on a restraining order and he couldn't talk to her. And so he stole those back that evening, which when the family said to the detectives, you know, what did he take or what happened? He said, well, they took guns and they took some money. And oddly enough, they took a stack of love letters that a guy that just got out of prison had given to my son to keep for safekeeping. And that sort of led them right to him. And so that's the kind of individual. He would write notes constantly to his lawyer, clearly indicating he was unhappy with some aspect of it. When we get back into the jury room, the jurors would have a little game of trying to figure out what was on each of the notes, you know, and had no idea, but they were basically fascinated by it. They also were fascinated why he didn't plea. And I knew why he didn't plea, because if you're going to steal stuff, steal like crockery or utensils. Stealing guns is a add-on to sentencing and stuff, and he wasn't going to get a deal. And and if I had said, well, I think I know why he's not pleading because the statute provides a kicker, that would have given me away. So I kept that to myself.
Do you think that the jurors carefully followed my instruction about the obligation to make the state prove the case beyond a reasonable doubt? Was there conversation about that? Because we, at least I did as a trial judge, worry about whether jurors are concluding that defendants are guilty because they probably did it, as opposed to the state proving beyond a reasonable doubt that they did the crime.
I don't remember hand-wringing or angst or dispute or discussion of that, but I think that was because this guy was dead on arrival. You know, he had motive, he had opportunity, he had a different girlfriend who had driven him to the crime scene, who had made her own deal and was there that night, who was very credible. And so people were turning over and testifying against him. So he was going nowhere. This was not a case where people had to worry about fine shadings of the burden
Right,
of proof.
right.
They would have been delighted, my jury would have been delighted to have found him guilty to a moral certainty. You know, there was not
Yeah.
going to be any question.
Right.
He was
I see.
gone.
I see.
And he had nowhere to
Yeah.
plea, and it was just going to happen that way.
Given your experience in that case, do you have any views about how trials should be done differently than they're done now?
No, not huge differences, but I'll tell you the one thing that I think is pretty critical is, and I know you are a strong supporter of it, I don't think there's any substitute for lawyer-directed voir dire. I don't think, I have huge respect for jurors and have tried many scores of jury cases. But I've seen jurors with implicit bias. I've dealt with it. I've heard stories afterwards. You know, you just have to find out not so much who the best jurors are. You just have to get rid of the ones that just have a low probability of being fair.
Right.
And trial judges are occasionally good at it. At sidebar, occasionally good at it, but in general are not good at it. They tend to focus on prejudice and whether the juror is conflicted out, rather than whether the juror is just somebody that isn't going to pay attention or isn't going to, you know, be able to get past some, you know, not real strident bias, but just something that would make them a bad juror. It's really hard to do, but I think lawyers are so much better at it than trial judge. And it's the most important part. If you don't get a fair panel, you know, everything else that comes after it is a waste. So to be saying, well, we'll give you 10 minutes to do it or 20 minutes is ridiculous. It doesn't need to be more than an hour, but each side should get 45 minutes or an hour.
And you had the experience in other states of more than 10 minutes.
Oh, yeah, and
yeah.
I've had the experience here of more than 10 minutes because many judges will say, look, you know, we waste lots of time in this courtroom. This is not going to be a waste of time.
Right.
So this is going to be valuable. So.
Yeah, good. As we conclude, let me ask you a question that we didn't talk about in advance. If you had it to do all over again, would you be a lawyer?
Oh, sure. I mean, I don't know that there's another, you know, career out there that I necessarily aspire to. There are things I do differently, but most of the things I do the same way. I think that the places where you tend to second guess yourself is whether you should have taken more time off or whether you should have devoted more. I think I've done okay on that. We've traveled a lot. The family's doing good. We have 6 grandkids. I think one thing I didn't mention before about how you maintain your sanity is I think it's useful to, location is important in our lives, and I think it's useful for people to find a location which serves as a refuge for them. And it'll vary. I'm not sure the 9th hole on the golf course is a perfect refuge. We bought in 1999 at a time when we didn't have the money to do it, a cottage up in the north woods of Maine and on Rangeley Lake, and we're there most weekends. It's become the family gathering place. I do a lot of work there. But there are loons, there are moose, there are eagles, there's fly fishing, there's a boat, there's now a floating unicorn that the grandkids float on in the swimming area. And I think that when you're there, even if work intrudes, you have a sense that it's worthwhile, that this provides that release. And you know, I think that maximizing that kind of family time is better done if you structure places where it can occur regularly. And you can do that in a lot of different ways. But you know, merely saying I'll pick you up and take you to the soccer game or the Little League game isn't quite a substitute for having a place where you can really have family gatherings. My grandkids have now got a habit of insisting that, because I did this and I started it, when they come for the weekend, they ask when they arrive, Grandpa, what's going to be the theme for dinner tonight? And that's because we have a lot of themed dinners. We last Labor Day we had cowboy night and we had pirate night, and so you know, you whimsy and having that kind of a separate world is a valuable place to go to. And there is a sense when we get out of the car in Rangeley that we've left some of the hullabaloo of being a trial lawyer behind.
I lied when I said no more questions. What has motivated you to make your bow tie the expression of who you are? because I think many young lawyers, if I say Bruce Felmly, they say bow ties and fishing.
Probably narcissism would be the answer. My dad wore bow ties, not all the time, but did, and would dress me up for Sunday school in bow ties. I admired some people that were doing it. Dort Big used to wear bow ties from time to time, and I just sort of started wearing them a little bit. And every time I wore them, people commented, interesting. Maybe I crave attention. And so, to some degree, we do things because we want to have, we get noticed, I suppose, or people identify us.
Yeah.
It's very surprising to me. I've had jurors from cases that I tried 10 years ago come up and see me, not with a bow tie on, but sometimes with a bow tie on, at the meat market in the counter at the supermarket, and said to me, "You don't remember me, do you?" And I said, "I'm sorry, I don't." He says, "I was juror number 4 in the case. You were the guy in the bow tie. What's your name again?" And so
Yes,
I don't know.
yes.
I have partners who say I'd win more cases if I wore big boy ties, the ones that go along, but I'm not sure I'd buy that. So
Well.
that's as good a reason as any, but I've got a lot of bow ties. It also is a great thing for the people that are buying you gifts for Christmas, because they always know you can use another bow tie.
Wow. Thank you, Bruce.
Thank
It's
you.
been great.
It was fun. Thank you.